The following is paid advertisement and does not reflect the opinions of this station. The choice of a lawyer is an important decision and should not be based solely on advertisements. The information presented in this program is general and is not intended to be legal advice and should not be relied upon or used without consulting a lawyer to consider your specific circumstances.
Questions about law, stories from the courtroom, cases that might impact your life. It's time for Tell Me I Have a Case with Dan Grimm and Matt Glenn from Cook, Barkat, Ponder, and Wolves. Find them at cbpw-law.com. Here's Dan Grimm and Matt Glenn.
Good morning and welcome back to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. I'm Matt Glenn alongside my partner and colleague Dan Grimm. Dan, say hello.
Hello.
You can find us on the web at www.cbpw-law.com or you can call the show at 573-708-7105. Today we are joined by a special guest, John Grimm. John is the past president of the Missouri Bar. He has been selected to the Missouri and Kansas Super Lawyer designation. He has an AV peer review rating from Martindale-Hubbell, which is the highest rating available, and he was the inspiration behind two of the three characters in the movie The Three Amigos. I'm excited to have John with us. John, tell the folks a little about yourself. Where'd you grow up?
Well, I grew up here in Cape Girardeau, and unlike my friend Dan here, who's from St. Louis, no relation to Dan.
Big city.
But
you got to clear that up immediately.
Yeah, that's right. No misconceptions there. But born and raised here in Cape, lived here most of the 60 years I've been alive, except for a few years in Kansas City for law school and a couple years in St. Louis thereafter.
Excellent. And your legal career, has that been mostly here in Cape Girardeau?
For the most part, I spent the first 2 years out of law school working in the federal court system in St. Louis, and then I've been in Cape ever since.
And you are now a partner at the Limbaugh Law Firm, is that right?
I am.
And people can find you there on the web at, what is your website?
It's limbaughLaw.com.
Right. For all your defense attorney needs, if you need an injury attorney, it's the other Grimm that you want.
That's right. That's right.
One of the things you've done in your career is, I believe you spent some time as a judge on the bench here in Cape Girardeau. How long were you serving as a judge?
Just under 9.5 years.
That's a fair amount of time.
Got to see a lot of different things during that time.
Yeah.
And I always thought it's fascinating. Can you describe what it's like being a judge, or what it was like as far as a private practice?
Sure. It's really like being the referee in a ball game instead of a player. I mean, everybody's got a different role to serve, and it's all part of the process. But the judge is the referee and presides over trials and makes sure that everything runs smoothly and efficiently, and you try to get to a just result in the end.
Yeah. We talk a lot about the phases of our litigation with clients. They come in, and once we file a lawsuit, we kind of get into a discovery phase. The judges can play a pretty large role in that phase. What sort of things did you see as a judge during discovery?
Well, ideally, the lawyers are, when they're trying to gather information about a lawsuit, which is the discovery phase that you're talking about, that's going to go along following the Supreme Court rules, and that there aren't disputes between the lawyers about what's proper and what's not, but there are sometimes disputes. And it's not because one lawyer's doing something improper, but sometimes a lot of it's subject to interpretation, and so there may be disagreements under the court rules what is proper information that one side has to disclose to the other, and so that's where judges get involved, and they say, again, they're the referee and say, well, yes or no, certain information does or does not have to be disclosed.
And I know one of the areas that in civil litigation comes up a lot is the idea of, is information privileged? We tell our clients all the time, if you write to us, that is a privileged communication, the other side doesn't get to see that. But a lot of times that can be disputed, and that's when a judge gets involved.
Absolutely, and the judges sometimes have to look at specific documents. Certain documents may be actually produced to the court, to the judge privately, referred to in camera, confidentially. Mm-hmm. The judge may look through documents and say, these have to be produced, these don't. And at the end of the day, you're trying to figure out what's fair to both sides, and so that the lawsuit can proceed.
Right. And some of the things when we talk to our clients, they're shocked when we talk about getting a trial setting and an ultimate trial date. Clients are just shocked when we say, it's probably your trial date's going to be about 12, 15, 18 months out, if not further. Why is that?
Well, I think a couple of different reasons. One is this discovery process of gathering information just takes a long time in itself. you send interrogatories, which are written questions, and the other side has 30 days to respond. Well, sometimes 30 days isn't enough, so that it gets extended to 60 or 90 days. And you certainly want to gather some basic information first, and then those parties want to start doing depositions and asking, finding out under oath, putting witnesses under oath and finding out what they're going to say. Well, it sounds simple enough, but if you've got 2 or 3 or 4 lawyers in a case, sometimes more, just the scheduling of those can take quite a bit of time. And we all have had cases together or against each other. Sometimes it may take 2 or 3 months just to find some dates that everyone has in common. And then by the time you get all of that process done, and there's expert witnesses, and it just takes a long time. And then you go into court and you say, "Hey, Judge, can I have a setting on this case?" And largely because of the volume of the criminal cases that judges are handling in this area, if you go in today and ask for a 2 or 3 day trial setting, Judge Lewis or Judge Lipke is very likely going to give you a date next summer or fall, and just because they've got many other cases scheduled.
Yeah, well, and one of the things you have to balance as a judge is the constitutional right to a speedy trial in criminal cases.
Absolutely.
How does that impact what Dan and I do with civil cases?
Well, the criminal cases take precedence, and it's not just the right to speedy trial, but keeping in mind that in many cases, criminal defendants are in custody.
Right.
And so the prosecutors and defense lawyers want to get those cases to trial as quickly as possible. So those cases, if there's a conflict between a criminal case going to trial and a civil case, it's almost always going to be the criminal case that takes precedence.
And when you're on the bench, what do you see as a breakdown as far as family law cases versus criminal versus civil cases?
Well, a high percentage are criminal and family law cases. I'm going to say in this area probably 80% or more of the cases that any of the judges have pending fall in those two categories, and then the civil cases that the three of us handle are in the other 20%, maybe less than the other 20%.
Right. Yeah, one of the things we talk to our clients about a lot of times, whether it's a premises case or a products liability case or a car accident case, a lot of times they'll say, "Well, there's no way this isn't the defendant's fault. Why do we have to even go to a jury? Can't we just tell the judge, all the facts?" And we say, well, there is that summary judgment motion. We can make a motion to the judge and say, "Hey, take liability off the table here." But how hard is it to get summary judgment granted in a civil case?
Very difficult.
Yeah.
I think that we rarely file them when we're on the defense side, just because we know that most of the time it's going to be denied. And I think most judges think that both parties deserve their day in court, and they're very hesitant to make a preliminary ruling that one side or the other doesn't even get to present their case to a jury.
Yeah, we found that too. They're just, we almost never file them, just for that purpose.
Pretty rare.
Yeah. So,
because I guess it's always a question of fact. I mean, it's and that's the standard essentially.
Yeah, that's right, Dan. And in many cases, there's going to be factual disputes, and that's for a jury to decide, and not for the judge to decide preliminarily.
Yeah. One of the things I think people out there listening, many of them may have had an injury case before, but I think a lot of people their run-in with the civil justice system would become when they become a juror. And I'd like to give folks a little bit of a sense of how much work goes into trying a case by the judge, by the attorneys involved, and how much, because I know they're sitting in a room wondering what's going on. Why are we in the dark about this? But oftentimes you have to settle certain matters pre-trial in order to ensure both sides have a fair trial. What sort of issues would tend to crop up during a pre-trial conference?
Well, the main thing has to do with evidentiary issues. Under our court rules and case law, there are certain types of evidence that a jury is entitled to hear, and other types of evidence that by law must be excluded. And so a lot of times the lawyers can agree on what comes in and what doesn't, but in other instances, there's a dispute about whether certain evidence should be heard by a jury, and so a judge is going to make that decision and tell the lawyers, yes, this can be heard by the jury, or no, it can't. So that's by far the biggest issue that is taken up out of the hearing of a jury. And then sometimes there are logistics issues, when certain witnesses are going to be available to testify and how long they're going to take. And because a judge, again, as a referee, is not only deciding things about what actually takes place in the courtroom, but what time we start and what time we end, and what witnesses are going to be heard on a given day. And so there's a lot of logistics that the judge is working out with the lawyers, and it's stuff that not trying to keep secrets from jurors, but is certain matters that have to be taken up out of their hearing.
And it's important for our clients to understand that there's some things that the jurors simply won't hear. For example, auto insurance or insurance policy. That's something that they'll never even know how much insurance there is or if there's any insurance at all.
Yeah, I think that's right. And there's a lot of things. The rules are pretty clear, but at the same time, there's room for interpretation, and it's up to the judge to make the final call on what comes into evidence. About serving on jury duty is really a neat opportunity that I hope people take advantage of, and all of us recognize what that it's an inconvenience for people, but I think many people are unnecessarily scared of serving on jury duty or feeling like they don't know enough to serve on jury duty. Those folks who I've talked to have done it. Almost everybody appreciates the fact that they've done it and says, that was a really great experience. I'm glad I had that opportunity.
Yeah, we're always looking for people who've served because, the one part of the process that we as lawyers don't get to engage in is that deliberation in that back room.
That's right. I was called on jury duty in a criminal case a few years ago, and I was really, really hoping that I would get selected. I didn't, but I really would have liked to. And I would really encourage people, if they get that card, I get calls from friends and family members to say, hey, can you get me out of this? And I say, you need to go do this. It's a great experience, and I think you'd enjoy it. And those who get picked really, really do enjoy it. Yeah,
and the judges that we work with, if you have a vacation that you've paid for already, or you've got, a child who is, gets the flu and you need to stay home with them, they're usually really understanding about issues like that.
Absolutely, Matt. That's a great point. And nobody's going to make you cancel a vacation to serve on jury duty, but it can be an inconvenience with your work schedule or other activities. But it's something that is, it's part of being a privilege in a society where we have lots of freedoms. It's an obligation that we have, and people ought to honor, in my view.
Well, yeah, I think there are very few ways that citizens can affect policy or can affect their community and how it's governed. They can vote for people, they can volunteer, or they can serve on a jury. Because when you get back in that jury deliberation room, you speak for the citizens of Cape Girardeau County or whatever county you're in, and you get to say, hey, for this dispute with this set of facts, this is how we're going to find, and you speak for the entire community. It's a heck of an opportunity.
Absolutely.
And I think when people serve on a jury, after the fact, they realize, it was a fascinating process.
It is, and not to say it's easy. They're tough decisions, but it's an important part of our lives, and we want people we want to get a good cross-section of people who inconvenience themselves to help us make the system work.
Absolutely.
Yeah, and we definitely cannot do it without them. Not every juror can serve on every case, and a lot of times we have to, during the voir dire process, go to the judge and say, look, they've had a similar dispute, or they were the victim of this type of a crime, and they can't serve on the juror. That doesn't say anything about them or their ability to be fair. It just says they've had an experience that really excludes them in this case.
That's a great point. And some people are better suited for certain types of cases than the one that that they may be called for that particular day. But it certainly doesn't mean that they're not well suited for a trial. Maybe just not the one that they're there for that day.
Right. Everybody deserves a fair trial, with the possible exception of the cases you and I have together. That does it for our first segment. We'll be back in a few moments with John Grimm to talk more about being a judge and being a mediator. You're listening to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. For Dan Grimm, I'm Matt Glenn. Stick around.
Cook, Barquette, Ponder, and Wolz are very proud of the results they obtain for their clients, but you should know that past results afford no guarantee of future results, that every case is different and must be judged on its own merits, and that the choice of a lawyer is an important decision and should not be based solely on advertisements. And now, back to Tell Me I Have a Case with Dan Grimm and Matt Glenn.
Welcome back to segment 2 of Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. I'm Matt Glenn, partner at Cook, Barquette, Ponder, and Wolz, alongside my partner Dan Grimm. And we've been talking today with John Grimm, no relation, past president of the Missouri Bar and partner at the Limbaugh Law Firm. We talked in the first segment, John, about your work as a judge on the bench for 9.5 years, and that probably qualified you to do a lot of what you're doing now, which is working as a mediator. Tell the folks at home briefly what the role of a mediator is in an injury case.
Sure. Basically, it's just someone who's not a party to the litigation who tries to help facilitate a settlement. Mm-hmm. That's the short and simple version. And usually, I will get phone calls or an email from the lawyers involved in a lawsuit, and they say, "Hey, we're looking for a mediator," and we'll talk to them a little bit and make sure that there's no conflict of interest, and then get the thing scheduled, and we can talk about it a little bit more if you'd like.
In mediation, is that something you do strictly in Missouri, or do you go to other states?
I have all of my mediations have been in Missouri, although I have mediated by Zoom some out-of-state cases a couple of times. But it really, my focus is in Missouri because that's where I think I understand judges and juries in Missouri and how they're likely to view certain types of lawsuits.
Yeah, I've always told my clients heading into a mediation that it really represents kind of the last best chance to settle a case. At the end of the day, if you don't settle, you go in front of 12 strangers that none of us know and none of us will ever see again. And they're going to go into a room and take all of the numbers and facts and expert testimony, and they're going to sit in that room and tell our clients what their experience was worth. That's bizarre. And a mediator offers you a chance to kind of control that process.
That's right. It's when the clients have total control over the outcome. And sometimes they walk away from mediation even when it settles and may not be thrilled with the outcome. Mm-hmm. But in many cases, neither side is really happy with the outcome. But they have total control over it. And if they don't want to settle, this is not like an arbitration proceeding where there's a binding resolution reached. This is mediation is a voluntary process. And if one party or the other doesn't want to go along with a settlement proposal, they don't have to. They can pack up their bags and go home and continue on to trial.
And early in your practice, did you see mediation? Was that a tool used then?
Yeah, no, and I've been doing this for 35 years now, and not at all. Mediation was not something that happened at that point. It's really come around in the last 20 years or so. I'd say has become popular, and now we're mediating lots of lawsuits. Not every case. Many cases, I'm going to say 97 or 98% of the cases that are filed are settled without going to trial, but certainly a lot of those are settled through the help of a mediator.
Yeah. So usually once we've selected a mediator, and you're one of the ones that we use, you have a experience working as now a civil defense litigator, and the insurance companies on the other side who are going to write the check if we settle, they know you have that background, and they tend to, we feel, trust you a little bit more because you've had that experience defending cases and the experience on the bench seeing how these things typically come out in front of a jury. So once we've chosen you, you usually ask us for what is known as a pre-mediation statement. And we usually write confidential at the top of it. Talk about the role of those in the mediation.
Sure. I usually get from each of the parties a letter or memorandum outlining what the facts are and telling me a little bit about the case. I want to know before I walk in the conference room with the parties the day of mediation, what's the case about? And I'll read those from each side, and I'll look at the pleadings that are on file in the court case, and in some cases I'll call the lawyers to talk about the case in advance, and when they come into our offices, we put the parties in separate rooms. It's not everybody. It's not all folks in one room. I'll put if Matt is representing the plaintiff, I'll put you in with your client in one room, and I'll put the defense lawyer usually with an insurance adjuster in the other room, and I'll go back and forth between the two rooms throughout the day and try to settle the case. But I early on in the day, well, even before the mediation, and then early on the day of mediation, I'm trying to get as much information as I can about the lawsuit, but also about the parties, and trying to figure out the personalities involved and what's driving the case, and things that can be helpful for me, and as I share information with each side, what are going to be important points that can really help affect the settlement.
And you mentioned Zoom earlier. So pre-COVID, it seemed like every mediation was done in person at a conference, in a conference room or office like yours. Now, with COVID, Zoom has seemed like it's an option now as well. Do you have a personal opinion as one way or the other if Zoom is effective or not effective as in person?
Yeah, that's a good question, Dan. And I prefer in-person mediations because I like to try to build rapport with people, and I think that's difficult to do over a TV camera or a computer camera. But that said, there's some advantages to Zoom, or you may have out-of-town participants who don't want to come to Cape Girardeau for a mediation, or they will just be on a telephone call, participating in the mediation by phone, and Zoom is preferable to that. And so I think it depends on each case. And our statistics have been statistically the Zoom mediations have had a not quite as good a settlement rate, but almost as good a settlement rate as the in-person mediations. So there's a place for them. I still prefer the in-person, but Zoom is becoming more and more popular.
Yeah, I agree on the in-person. I mean, one of the things our clients really want to have happen during their case is they want to be heard.
Sure.
They want their story told in some capacity, and sometimes we tell their story to a jury, but sometimes we tell it to a mediator. And we say it to this neutral third party who can then say, yeah, I understand. I see you. I see you're hurt. Here's where your case is strong. Here's where it's weak. And here's where they're coming from. But they at least get that opportunity to tell the mediator, hey, this is what happened.
Well, and that's true, and that's a great point. And as you all know from mediations that you've done with me, even though I get information in advance from the lawyers, I like to engage personally with with your client who's who's been injured in some sort of accident, and I'll ask the client questions directly and want to hear from them, and partially for the reasons that you're talking about, Matt. I want them to know that I'm hearing them and that they have a voice in the process. And in fact, I tell them, you're in charge. I said Matt or Dan, they're great lawyers and they have great advice to give you, but Mr. So-and-so or Miss So-and-so, you're in charge today, and you're the one calling the shots.
So we always represent the injured victim, and so prior to mediation, we always kind of tell the clients, what's going to happen, expectations, who's going to be there. So our clients are always with us at mediation. But one of the questions we always get from our clients is the defendant driver going to be there, or the at-fault party? Will they be at mediation? And what do you see as far as how often are they there? Does it make a difference?
Well, the answer is they're almost never there because in the cases that you guys are handling, there's almost always an insurance company involved, and the insurance company is calling the shots on dollar amount of settlement, and really every once in a while they'll have the named defendant at a mediation, but most of the time it's the lawyer hired by the insurance company who's representing that named defendant, and an insurance adjuster who's calling the shots. And I've seen a few exceptions to that, but certainly that's typically the case.
We talked earlier about evidence. Something a jury would never hear is what the insurance policy is. At mediation, that's out front on the table. Sure,
and especially from your point of view, you want to know what that policy is, and it's something that you all find out, and it does affect the settlement discussion. So it's something that you're right, jury's not going to hear, but something that needs to be part of the discussion in a mediation.
Yeah, and something else the jury's not going to hear is any numbers that are exchanged at mediation.
Great point. Mediation under our court rules is all settlement discussions are confidential. The jury can't hear. Well, they offered me $50,000 in mediation. Why are they saying they don't know anything at trial. And,
Right.
and it's part of settlement discussions, and the court, under court rules, those are all confidential.
Yeah.
And you have an impressive background as far as being a judge in private practice and then moving into mediation. What do you see as far as what skill sets have you developed that you find that make you successful or set you apart from other mediators?
Well, I think Matt alluded earlier, people want to be heard. And one of the things that I do is listen to people. I do like to talk directly to plaintiffs in particular, and spend a lot of time with them in the early stages of mediation, and find out what their injuries are, and what's still bothering them today, and the types of things. And so I try to develop a rapport with people and listen to them and let them know that that I'm hearing them. I also say, though, I'm not their advocate. They've got a very good lawyer in Matt or Dan or whoever is representing the plaintiffs. I'm not their advocate, but I do want them to know that I'm hearing them and conveying their concerns and to the other side, and then I'll go into the other side's room and convey what they're saying. So I want both sides to feel like I'm hearing them. I'm relaying information to the other room, and also giving my observation and take on the case, and about strengths and weaknesses and things that the lawyers as advocates. You guys are good lawyers, and you can evaluate a case. You guys do a great job with that, but sometimes it helps the clients to hear it from a third party who doesn't have a dog in the fight, and whether it's the insurance adjuster or your clients, sometimes it's a validation of what you're already telling them, but they just want to make sure that somebody else thinks the same thing.
So true.
Yeah, I always consider it a successful mediation if all of the pushback that comes from the other room is stuff I've already told my client. This is likely what they're going to say. If you come at me with something completely new, then I know that there's probably something out there I missed. But
Yeah.
it's a valuable part of that process. And Dan alluded to it. Your skill set, you can see that when you're interacting with the plaintiff, that you have a sense that there are 5 or 6 people involved in this mediation, but for all but one of them, we're working, we're doing our job. We're doing what we do to earn a living. For the one plaintiff, it's because they had an experience. Right.
I think that's absolutely right, and they're there because of some injury that they've sustained, and I think you're right. They want to be heard and make sure that their point of view gets conveyed to the other side, and that's what I try to do.
Yeah, I always tell my clients, he'll come push back at us, but then he's going to go in there. He's going to push back against them too. He's going to kind of jostle with both sides to make sure that both of us understand really what the risk is. You get that third party perspective on the risk of going forward.
Yeah, that's true. You want both sides to make informed decisions about do I make this certain settlement proposal, and by sharing information and taking into consideration my observations and comments, hopefully it gets both sides to modify their settlement positions to the point that the case gets settled.
And what do you like to see at mediation? Do you like to see maybe, I'd call it a mini trial, like with an opening statement and a PowerPoint, or do you have a preference one way or the other?
I don't know that I don't have a strong preference, but I can tell you what's successful, and in most cases, to have the lawyer making an opening statement like you would in front of a jury usually is not effective. The insurance adjusters usually are not persuaded by that, and so I prefer just to get into the settlement process and not spend 30 or 45 minutes with those trial type of opening statements.
I think that's a better way of doing it. I've been with mediators who require opening statements, and it gets really delicate. On the one hand, the plaintiff's attorney can really thunder away with a story because he knows he's talking to an insurance adjuster. On the other hand, the defense attorney has to lay out the defense in front of a plaintiff and oftentimes their spouse, and that's not somebody who really wants to hear it, and that can be a tough way to kick off settlement negotiations.
Yeah, sometimes you may take a couple of steps backward before you can start progressing, and so most of the time we don't do that. They can a few very minor comments can sometimes be helpful. I've had mediations where there's been a tragic death that's a death that has occurred, and sometimes the defendant, in some cases even the named defendant, has been there to say, "I'm sorry this happened.
Yeah.
I hate that we're here, and I feel really badly about it. I hope we can get this settled." And sometimes that sincere apology can really start things off on the right note toward a resolution. And so that'd be the
So true.
exception
So
to
Sure.
to the general rule of not doing opening statements.
What's the longest mediation you've done?
Oh, I was a party for one that started at 10 a.m. and finished at 2 a.m. the next morning. But the one as a mediator, the longest single-day mediation was, I think, finished about 11 p.m. But I've done multi-day mediations, too, where it's been 2 8-hour days in some
And
cases.
so something we always tell our clients is that stick with it, right? Stick with it.
That's part of my speech at the beginning. It's impossible to tell in the first few hours which cases are going to settle and which don't. My favorite story was about an old man at 2 o'clock. He was about ready to give up and go home, and I said, "Sir, if I could get you a little bit more money in the next 30 minutes, would it be worthwhile?" And he slammed his hand down. He says, "You got till 2:30." Well, we got a deal signed at 7:30 that evening, and he was there every step of the way.
We want to thank our guest, John Grimm of the Limbaugh Law Firm. He is past Missouri Bar President and mediator and former judge here in Cape County. Our apologies to Michael Avenatti. We ran out of time. He's had a really rough month, and so it was really lousy to bump him. But this has been Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. For Dan Grimm, Matt Glenn, and all of us at Cook, Barquette, Ponder, and Wolves, thanks for listening.
You've been listening to Tell Me I Have a Case with Dan Grimm and Matt Glenn. If you have questions and need answers, contact Cook, Barquette, Ponder, and Wolves today. Just go to cbpw-law.com. See you next week for Tell Me I Have a Case. The choice of a lawyer is an important decision and shouldn't be based solely on advertisements.